Hello and welcome. I'm Peter Afrasiabi. I'm a partner at One LLP, and I'm the host of The Curious Lawyer. For those of you who've seen various of our Curious Lawyer programs, you'll know they're fun walks down off the beaten paths of the law, where you can have some edutainment and go somewhere different that you're not used to going. It's not the mundane, difficult stuff that may be tedious for where you practice law every day. It's fun, entertaining, educational areas of the law that you don't know that you can use to intersect with how you practice. So you can go and watch dog law, CIA law, celebrity and paparazzi law, presidential pardon law, and space law, a whole variety of programs at The Curious Lawyer. You can even see one on whether there's a place in Yellowstone National Park where you can get away with murder. Is there a crime-free murder zone? I'm not going to tell you the answer to that. You got to go watch the program to find out. Today's program from our Curious Lawyer is our Bill of Rights series. And in our Bill of Rights series, we explored the first 10 amendments to the U.S. Constitution, 1 hour on each amendment, so that you can become an expert again, as maybe you were in law school or when you were studying for the bar, or maybe you never took some of the bar classes or law school classes in certain areas of the law that some of the amendments touch. In any event, now you can become a well-rounded lawyer. You can spend 1 hour on each of the first 10 amendments, and in 10 hours, you'll be the master of the Bill of Rights. So the next time you're at a cocktail party and someone asks you, what's the Third Amendment about? You'll know the answer to that question. Today, we're looking at the Fifth Amendment. And so the Fifth Amendment, as you see here, we'll start by actually reading it. No person shall be held to answer for a capital or otherwise infamous crime unless on a presentation or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia when in actual service in time of war or public danger. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb. Nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. So that long set of clauses, as you see on the next slide here, distills into 5 core issues. The Fifth Amendment, that is, has 5 basic points to it. It's perfectly numbered. I don't know if they did that intentionally, but it turns out that the Fifth Amendment has kind of 5 core rights in it. And we're going to explore them today. The right to a grand jury for felony indictments. And we're going to explore that, what it means, how does it work, what's the basic case law from the U.S. Supreme Court. And we're also going to look at where the First Amendment collides with this in terms of the rights of those on grand juries, former grand jurors, to discuss what happened. We're going to look at number 2, the second pillar of the 5 pillars, the prohibition on double jeopardy. We're going to look at how it works. What is double jeopardy exactly? And of course, you knew it was coming. We have to look at the famous Ashley Judd movie called Double Jeopardy to figure out, was it right or was it wrong when she murdered her husband for the second time? We're going to look at the right against forced self-incrimination. We're going to look at the guarantee of a fair trial to criminal defendants, the core of due process and the nature of substantive and procedural due process. And of course, we're going to look at just compensation for seized private property so we can understand how the rules work currently, how they're likely to work in the future given the changing makeup on SCOTUS. And of course, in all this, we're going to look at SCOTUS holdings in all the major areas, and you're going to get the answer to double jeopardy, but you got to wait. So I'm not going to tell you what the answer is. Keep watching, and you'll know soon as to whether Ashley Judd would have gotten away with it or not. Let's look again at the Fifth Amendment just to remind ourselves of those core pillars. It's really useful in all these Bill of Rights programs, I think, to constantly pivot back to the language. I mean, it's the core of what we're talking about, and we want to keep it in our mind, and we want to keep it front and center. And so it's worth and bears really repeating, given how important the amendment is. You can't be held to answer for a capital or otherwise infamous crime unless you're indicted by a grand jury. That's the first part of it. Then you go down to the semicolon, then we have, nor shall any person be subject for the same offense to be twice put in jeopardy. Nor shall you be compelled in a criminal case to be a witness against yourself. Nor can you be deprived of life, liberty, or property without due process of law. And nor can private property be taken for a public use without just compensation. So let's get going on our 5 pillars, and let's move along here to the very first one, the grand jury right. No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury. So let's start exploring and talking about what this Fifth Amendment right to a grand jury actually means. And so we can explore it by understanding a little bit about the history and the purpose of the grand jury clause. And you see here on our slide, we'll start with the purpose. And the purpose fundamentally was to find a fair method to institute criminal process against a potential wrongdoer. And the idea of grand juries actually go back to ancient Greece, the 1100s in England, and then over the development of the common law in England, where over time it developed into a set of powers independent of the crown. That is, that the ability of the state to place criminal process on someone was divorced and made independent of the king's ability just to say, I prosecute you, you're going to jail, right? I mean, we wanted something that was more independent, fairer, better. And so the result of this is that by the time you had, we reached the 1600s and we have the very, very early colonies on our continent, laws were passed in those colonies actually requiring grand juries. And so then when you fast forward a century to the founding of our republic, the idea of grand juries then was central and critical and important and became embedded then in the Fifth Amendment. Now, the modern function of grand juries is to investigate potential crimes, subpoena witnesses, hear testimony, and they operate in heavy secrecy. And so these grand jurors are just folks from the community like you or me who are asked to be on a jury. And this time, instead of it being a jury deciding a specific case, they're grand jurors. And so they serve a term generally for a period of weeks or months, it may be. And they go in and they meet and they are able to listen to evidence. Witnesses can come and be subpoenaed to provide testimony. And they listen to all this and decide whether there's a basis, a probable cause for purposes of an indictment then being issued so that the criminal process can then start against someone. And so a good modern example, I just pulled this, but it's very prototypical in the federal courts and the state system is not that different. But a good modern example is here from the Central District of California, where it's a 12-month term for grand jurors. They meet once a week for 5 hours, for at least 5 hours really, and that's for the investigatory jurors. There's 23 members on the panel, and they meet to discuss whether there's probable cause for specific indictments based on the evidence being presented to them by prosecutors. Now, what's important to keep in mind and remember here is that this is a one-sided process. I mean, the defendant doesn't know that there's a grand jury proceeding afoot about him or her, and they're not there to present counter evidence. So it is one-sided, and it's simply to assess and establish whether there's probable cause such that for these certain felony indictments, the indicting power of the government can be brought to bear on people. And that's our big picture history and purpose. So let's move along to the case of Costello versus United States. It's reported at 350 U.S. 359. And this is a 1956 U.S. Supreme Court case dealing with grand juries. And so let's start with what this case is about. It was an indictment for tax evasion. And so Mr. Costello, a grand jury convened, A, B, C, D, E, F, G happened in the grand jury, and boom, he got indicted for tax evasion. Post-indictment, he's angry, horrified, upset, shocked, you name it. And he starts doing investigation into understanding, what was going on in this grand jury process? Why was I indicted? What was the evidence they looked at? What was going on? And in that investigatory process, he discovered that the government agents who had testified before the grand jury about his alleged tax evasion actually had no firsthand knowledge whatsoever about anything he had done. And so all they could offer was sort of third-hand hearsay, basically, in terms of their, if not speculation, in terms of understanding what documents may or may not have meant that they didn't author and what may or may not have happened. And so he moved to dismiss the indictment, saying that's not even evidence. It's not non-first-hand knowledge type stuff. It's just made up. That can't be enough for a grand jury to indict me. And so he brings that motion to dismiss, and this case works its way up to the U.S. Supreme Court. And here we have the U.S. Supreme Court holding that, and it's a great little case to go read to get more of the history of the grand jury in terms of how it evolved over time and then into our legal heritage as part of our Bill of Rights. But here's what the court said. The grand jury is an English institution brought to this country by the early colonists and incorporated in the Constitution by the founders. There's every reason to believe that our constitutional grand jury was intended to operate substantially like its English progenitor. The basic purpose of the English grand jury was to provide a fair method for instituting criminal proceedings against persons believed to have committed crimes. Grand jurors were selected from the body of the people, and their work was not hampered by rigid procedural or evidentiary rules. In fact, grand jurors could act on their own knowledge and were free to make their presentments or indictments on such information as they deemed satisfactory. End quote. So you see, the breadth and scope of how they work was such that they were never bound rigidly by rules of evidence, as rules of evidence that apply in our court proceedings, of course. And so what the U.S. Supreme Court held then is that hearsay evidence can be used to justify an indictment, and that the rules of evidence are for trial to ensure a fair process in the trial. It's part of the due process that we're going to talk about in a little while. But for purposes of the grand jury actually issuing indictment, yep, not a problem for, government agents to get up and talk about stuff that they didn't have firsthand knowledge of, if it shone a light factually on what may have happened. And that's enough for an indictment. The government better have the right evidence down the road to prove its case, but for purposes of an indictment, it's okay. This is a very, very important case then in the history of grand juries because it establishes that basic idea that grand jurors act not only in secret, but with great breadth of freedom to explore information. So now let's look at some limits on this secrecy in terms of the First Amendment colliding with secrecy of proceedings and how they work. And this is the case of Butterworth versus Smith at 494 U.S. 624, and it's from 1990. And this case involved a Florida state law. And the Florida state law prohibited those who'd been on grand juries from discussing after they got off the grand jury what had happened while they were on the grand jury. And so this case involved a reporter who had been on a grand jury, and he wanted to write an expose about the system from his experience as an insider, having been a grand jury, panelist, but also from witnesses he interviewed, and basically wanted to talk about, an expose on the system. Florida state law said he couldn't do it. Case went up to the U.S. Supreme Court. And in a 9-0 ruling, the U.S. Supreme Court held that after the grand jury term ends, the state's interest in secrecy ends, and people can disclose what they experienced as a grand juror. And so this is a very, very important case then where the U.S. Supreme Court back in 1990 really held that the secrecy that attaches ends when the proceedings are over. And at that point in time, people are free to discuss their experiences. This, of course, brings us to 2023, and it's breaking news because you see here a picture of a grand juror foreperson, Emily Kohrs, who was speaking to the New York Times in some of the President Trump grand jury investigations going on in Georgia, and she was apparently making kind of the press junket tours and being interviewed by the papers and the press and whatnot. And it sparked a lot of controversy about whether it's going to mess up, the potential, process down the road. Is it interfering? Is it causing problems and the like? But the truth is, she had every right to do this because of what the U.S. Supreme Court said in the Butterworth case. And there you see a quote from her saying, "You are not going to be shocked. It's not rocket science," as she was talking about what it is that grand jury is going to do. Stay tuned. Time will tell. You need to check out our Curious Lawyer program on President Trump down the road, and we will see what happens and how much rocket science there was or was not in the process. That brings us to our second module that we're going to talk about, and that is double jeopardy. And double jeopardy, again, it's the issue of nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb. So let's take a look at the governing test, and let's understand this, sort of the big picture of how it works. The big picture of double jeopardy is that a sovereign may not prosecute for the same crime twice. So once you're acquitted, there can be no re-prosecutions by that sovereign. Now remember, if there's a hung jury, the state can again prosecute. But what's very important about this test, and this is where it sort of collides with conventional, street wisdom, and so this is why at your next cocktail party, you're going to be the expert on double jeopardy, even though you're a civil lawyer and you've never been in criminal court like me. But what we now know is that the prohibition about being prosecuted for the same crime twice only applies to a given sovereign. And so there's this doctrine known as the dual sovereignty doctrine. And under that, a state can prosecute for the same conduct that the federal government can prosecute for. So let's double click on that and pause and read that paragraph again, because that's a significant statement that may be greatly at odds with a lot of what you've conventionally understood double jeopardy to mean. Let's explore then this idea that you actually can be placed in life or limb jeopardy twice for the same conduct if it's being done by two different sovereigns. Let's explore it. Moving along, we're going to look at a U.S. Supreme Court, a SCOTUS decision called Denespi versus United States. This is a recent case from June of 2022. If you want to look it up and read the full opinion, you can get it on Google, obviously, or on the Supreme Court's website. The case number is 20-7622. And here's the basic fact pattern in terms of what this case was about. The defendant was a member of the Navajo Nation and was prosecuted and convicted by the Navajo Nation and by the United States government for assault and battery and aggravated sexual abuse. And so he ended up being convicted in both courts. Now, the Navajo Nation court prosecuted him with employees that had been hired by the Bureau of Indian Affairs and in a court created by the Code of Federal Regulations, what's known as a CFR court. But this is a federal court that was created as part of the Department of the Interior that houses the Bureau of Indian Affairs. And so he argued that really this amounted to two convictions by actually the same national government, so that when he was prosecuted in our traditional federal courts by the U.S. attorneys, it's fundamentally the same sovereign as the Navajo Nation, since the Navajo Nation court that actually prosecuted him was, a Code of Federal Regulation court as part of the Department of the Interior, and it's the same national government prosecuting him twice. Sounds like a good argument, right? Turns out, not so much. In a 6-3 decision, the Supreme Court rejected Mr. Denespi's claim. And here's what it said. His acts violated two distinct authorities. There's the Ute Mountains Code's assault and battery ordinance, and then the United States Code's prescriptions against aggravated sexual abuse in Indian country. And these are two different sets of laws by two different sovereigns. And his single act violated those two distinct set of laws. And so the quote you see here from SCOTUS in this 6-3 decision is that the two laws defined by separate sovereigns therefore prescribe separate offenses. The double jeopardy clause does not prohibit successive prosecution by the same sovereign. It prohibits successive prosecutions for the same offense. This is a critical fault line to understand and keep in mind, and it shows how the dual sovereign doctrine is very elastic, very broad. And it's, in other words, in order to have a double jeopardy escape card, it needs to be literally the same sovereign. So let's move along now, and we're going to look at another case. This is from 2019. It's the case of Gamble versus United States, another U.S. Supreme Court case. It's case number 17-646. Another split decision again, but first let's talk about the facts. So you have a convicted felon named Mr. Gamble, and Mr. Gamble is driving along, and he gets pulled over for a broken taillight. And as he's pulled over for this broken taillight, the state officers found marijuana and a handgun. And that possession of marijuana and the handgun led to a charge under state law of unlawful possession of, marijuana and a handgun. And he pled guilty and, took his conviction. Now, post-plea, Assistant United States Attorneys, the U.S. government, also charged him under the federal felon in possession statute. So he was a federal felon, he had a gun, shouldn't have had a gun, and marijuana. He was in possession of it. That's unlawful under federal law. So they then prosecute him. He files a motion to dismiss under double jeopardy, saying that I'm now being charged for the exact same thing twice. This is not okay. And nonetheless, he's out of luck. So this is at the 11th Circuit. So this goes up to Supreme Court, and here's what the Supreme Court holds in a 7-2 2 decision. And this is on the dual sovereign doctrine again. In adopting the Constitution, the people split the atom of sovereignty that often results in 2 layers of regulation and is part of our dual system of federalism. Concurrent jurisdiction does not offend double jeopardy and limits on the same sovereign from prosecuting the same offense twice. So again, it's another reaffirmation of the idea that your double jeopardy rights are actually very limited. Now, here's what's important. There's a very interesting dissent by Justices Gorsuch and Ginsburg, who normally, obviously, historically were more on opposite ends of the political spectrum, so to speak, on the court. But nonetheless, they were in the same place here on the dissent. And it's for those of you who have seen some of our other Curious Lawyer Bill of Rights programs, or you spend a lot of time thinking about the nature of the Commerce Clause and the expanding role of the federal government, both of them came together in a dissent arguing that there was a problem here and that the federal prosecution actually did violate double jeopardy. And here's what the dissent said. Starting from the premise that we now live in a world where there's an ever-expanding federal set of criminal laws, and that because the reach of the federal government with its endless march forward in terms of passing laws, regulating behavior, and overlapping with states has become so ubiquitous that really the dual doctrine's foundation has been utterly sort of gutted in essence, right? And that the framers never intended the word offense to be some sort of sovereign-specific idea whereby the federal and state governments are, not really distinct sovereigns, but they're really 2 expressions of a single sovereign. And that's the fundamental argument they made, which is, the idea that we have in this day and age 2 distinct governments doesn't make any sense when we're talking about double jeopardy. What we should really be doing is looking at it saying that we are a single sovereign people. We have 2 expressions of that on the federal and state side, but we're still a single sovereign. And if there's going to be a prosecution, there should be one by one sovereign. And we shouldn't have a world where, because the federal government has tread all the ground that the states have tread, and they literally almost have, right? Probably 80% of, state criminal laws have been federalized too. Because of that, they said, this is destroying the underlying foundation of the doctrine. It doesn't make any sense because, the doctrine, when the clause was established, the amendment was passed, and this doctrine existed, there was a hyper-limited federal government. So it was always understood that you're only going to be prosecuted by one sovereign. And so, in other words, they're frustrated that in the modern world, this 2 bite at the apple type thing really is kind of gutting the core idea of what double jeopardy was supposed to protect against. Now we're going to look at the other side of the line, though, with another Supreme Court case, and this is a case of Evans versus Michigan, reported at 568 U.S. 313 in 2013. And so here we have a situation where Mr. Evans was charged with setting a building on fire. And one of the laws at issue made it a crime to burn a dwelling, while a second made it a crime to burn other real property. Now, the jury instructions required that it be a non-dwelling before a person could be convicted of the crime of burning real property. So in other words, the crime in that state of burning real property required that the real property not be a dwelling. It had to be a non-dwelling. And at trial, the property owner said the building was a dwelling. And so the defendant said, aha, I'm entitled to an acquittal. I'm a judgment of acquittal. You just have to, acquit me because I can't have violated the law because the law requires it to be a non-dwelling. And the trial judge says, yeah, you're right, and issues an acquittal. Boom, acquittal issued. Well, the prosecution wasn't happy. They took that up on appeal, and they said, look, the trial judge erred. And he erred as a matter of law, they said, because it actually turns out under the state law that burning other real property is a lesser included offense of the greater crime of burning a dwelling. And so therefore, there actually is no requirement that it be a non-dwelling. It can be a dwelling, and you can still be guilty as a matter of law. And the prosecution then appealed, and the appellate court said, yeah, you get a new trial. You're right. That was absolute error by the judge in issuing the acquittal. The acquittal may not stand because, the evidence showed that, in fact, it was, it didn't matter that it was a dwelling. Now, this goes up to the U.S. Supreme Court. In an 8-1 decision, the Supreme Court now says that is a double jeopardy violation. And the reason it's a double jeopardy violation is because we are only dealing with a single sovereign this time, and because an acquittal was issued. And what the U.S. Supreme Court said is that once that acquittal issues, double jeopardy attaches. And it doesn't even matter if the acquittal attached because of pure legal error, like just egregious legal error like that. When a judge acquits someone, they're acquitted. They can never be tried again, even if the acquittal was issued due to legal error. And so that's an important example in terms of where acquittals can, radically sort of alter the playing field, and they could be wrong. And so, the majority went to great pains, though, to explain in this 8-1 decision that there's a lot of tools in the shed of, trial judges and prosecutors to deal with this in terms of taking an issue up on a writ, holding on to issuing acquittals until after a jury makes a decision and you have more time to look at this stuff and whatnot. In other words, fight against snap acquittals because you can never undo them. But at least we saw one person who at the U.S. Supreme Court managed to get out on double jeopardy and not have 2 convictions in 2 courts. Now we're going to talk about the Ashley Judd movie. And this is the 1990s movie that you all may have seen. If you haven't, it's actually a pretty cool movie. Go watch it. Fun popcorn flick. So what we have is Ashley Judd is convicted of murdering her husband. But it turns out she's totally set up. He never died. He made it look like he died. She goes to jail for murder. He absconds with the kid, the money, her best friend, whatever, you name it. Typical story then, right? So she's now in jail, and she gets out of jail eventually, and she decides she's going to exact revenge when she realizes he had done this. And so she tracks him down, and she says, we're talking to her jailhouse friend, and Tommy Lee Jones, you see there, who's like a marshal on the trail or something, he also confirms to her that, yeah, you know what? You can kill him. And you can't be prosecuted because you've already been convicted of murdering him. So you can't be convicted of murdering him twice. So you get a free murder card. So she gets to, go out and kill her terrible ex-husband who had done all this terrible stuff to her. Now, in the real world, and it was a great movie, and it's like, wow, you can get away with murder. Turns out you can't. Ms. Judd, you're not so lucky. That second revenge murder under double jeopardy analysis was actually a distinct act or offense. It's not the same offense. The original offense she was convicted of was some murder in some state in some year, and now there's a conviction of a different murder in a different state at a different time by a different set of authorities. And so it actually would not trigger the double jeopardy clause. So for those of you who think you're going to murder your spouse, please don't do it. Anyway, let's move along because truth can be stranger than fiction. And here we have a case that kind of starts exploring that. And this is the case of Heath versus Alabama. And this is a situation that went to the U.S. Supreme Court in 474 U.S. 82, 1985. And it's kind of a play on the Ashley Judd situation in terms of someone being, it's almost the inverse flip side of it where, it raised the question of, can someone be convicted in 2 states of one single murder? Which seems bizarre and odd given the nature of the ways the laws work. But let's take a look at what happened here. So, petitioner ends up being convicted of murdering, his wife, and he had a sort of kidnap, murder for hire type plan. She's, gets people to kidnap her, and she gets killed. And she's, this kidnap of her happens from her home in Alabama, and her body is then later found in Georgia. And so this then triggered 2 different prosecutions. And what happened is, in Georgia, he pled guilty to malice murder in the trial court in exchange for a sentence of life imprisonment so he could escape the death penalty. And so he said, okay, fine, I'm guilty of malice murder in Georgia, and I'll take life and avoid the death penalty. Now, then what happens is he's tried and convicted in Alabama of murder during a kidnapping, which is a different crime. But it's the same murder, obviously, of his wife. And the Alabama court said, well, no, murder during a kidnapping is a crime, and in Alabama, you get the death sentence. And so the Alabama trial court, he argued double jeopardy. I've already got life in Georgia. You can't do this. I can only be charged with murdering my wife once by one sovereign. The Alabama trial courts didn't agree, perhaps not shockingly, and said, no double jeopardy here. And so this then goes up to the U.S. Supreme Court in 1985, and in a 7-2 decision, here's what the U.S. Supreme Court held in the mid-'80s. The dual sovereignty doctrine provides that when a defendant in a single act violates the peace and dignity of two sovereigns by breaking the laws of each, he has committed two distinct offenses for double jeopardy purposes. So therefore, if you do a kidnap and murder plot of someone, you will violate the state law where you're doing the kidnap and murder. And if the kidnapping crosses state lines into another state where the murder then happens, or maybe that state's kidnap and murder law too, you can be tried in both distinct forms, even though it's the same underlying act and set of fact patterns, because a single act can violate the laws of each. And so they're two distinct offenses. And so that's how the Supreme Court said, nope, you end up with life in one and death in the other. You're out of luck, Mr. Heath. Now, there was a dissent by Brennan and Marshall, and here's what their dissent said. The dual sovereignty doctrine, heretofore used to permit federal and state prosecutions for the same offense, was born of the need to accommodate complementary state and federal concerns within our system of concurrent territorial jurisdictions. It cannot justify successive prosecutions by different states. Had the same state become dissatisfied with the life sentence petitioner received in their courts and re-indicted petitioner in order to seek the death penalty once again on the same facts, that indictment would without question be barred. Whether the second indictment repeated the charge of malice murder or instead charged murder in the course of a kidnapping, it would surely, under any reasonable constitutional standard, offend the bar to successive prosecutions for the same offense. That was Brennan and Marshall, and it turns out, I guess, since it was a 7-2 decision, their construct of what's a reasonable constitutional standard didn't find the light of day, and they lost, and so Mr. Heath got the death penalty. Another example then of perhaps this is the flip side of the Ashley Judd example we looked at, where it turns out you may not think it, but you could, commit a crime that you would think is one local crime, but it actually could violate two different state laws, and you could be convicted in each of very related offenses without, offending the double sovereignty doctrine, which has sort of greatly limited then the scope of one's perceived double jeopardy rights. So from there, let's go to our next module, and we're going to talk now about the right against self-incrimination. And so remember the language, nor shall one be compelled in any criminal case to be a witness against himself. Let's move along, and let's do a little bit of an overview here on pleading the Fifth. What does it mean in the Fifth Amendment, your Fifth Amendment right against self-incrimination, and of course the famous phrase we all say, I plead the Fifth. Let's talk about an overview and some of the rules that govern in this area. You can plead the Fifth Amendment and refuse to answer questions in response to a compelled communication, such as a subpoena, questions at trial, that type of process-oriented compelled communication situation. And the communication it attaches to must be testimonial, and so this would include words or gestures and even at times document productions that could be incriminating. The communication has to be self-incriminating, so substantively the court will have to look at it to make sure that indeed it is self-incriminating. Now, some of the framing rules here that frame how it works is that if a prosecutor decides to grant immunity, then you cannot assert it. And the same exists for pardons and even post-conviction and post-sentence defendants. So, once someone has been convicted and sentenced and now they're off and running, they can no longer plead the Fifth if called to testify, perhaps in a case, involving other people or other related crimes and the like against others. Now, in civil cases, and for those of you who are civil litigators like me, it may happen once in a great while that in a deposition, someone may assert Fifth Amendment and refuse to answer civil questions. And different states have different doctrines on this, but generally there are civil adverse inferences that can be drawn against the witness for invoking their federal criminal Fifth Amendment rights against self-incrimination. It varies by state, by jurisdiction, by scope, and by the nature of the adverse inference that can be provided. And of course, there's massive fights always about jury instructions and information given to juries in terms of how they can and how far they can go in terms of making adverse inference or concluding what it means. But as any of you have ever been in a deposition where it's happened, it's fascinating and certainly not a fun place for the person who's asserting it to be, nor their lawyer, I suspect. So let's take a look now at Miranda, the seminal case. You all knew it was coming. Miranda versus Arizona, 384 U.S. 436. This is a 1966 case. It was sort of one of the core Warren court precedents, and this deals with arrest notice at the time of arrest. And so the facts, for those of you, we all know Miranda because of the Miranda warning. If there's one thing I learned in law school or studying for the bar, it was a Miranda warning, right? Even though I never took criminal procedure. I knew the Miranda warning, although I think I got it from Law and Order. But nonetheless, here are the facts. Ernesto Miranda is arrested in his home, and he's brought to the police station where he's in question. And they're questioning him about a kidnapping and a rape. And after a few hours of interrogation, they get a written confession from Miranda. And then, prosecution happens, he goes to trial, and the written confession is admitted into evidence. Now, the defense attorney objected that he had never been advised of a right to have an attorney present during the interrogation. The police said, yeah, we never told him of any rights to have an attorney present. And the court said, well, it doesn't matter. They weren't obligated to do it. The confession still stands. It goes before the jury. You're convicted. You lose. You go to jail. And this case then goes up through the state courts in Arizona, and it goes up to the Supreme Court of Arizona that affirms and holds that there was no violation of Mr. Miranda's constitutional rights because he didn't specifically request counsel. In other words, at that time, if you wanted a lawyer, you had to ask yourself. No one had to tell you that you had the right to a lawyer. This then goes up to the U.S. Supreme Court, and in a massive 5-4 decision that has really sort of forever altered the landscape for all of us today, and our parents and our children and our children's children and our grandchildren, you name it, right? It's forever changed the nature of sort of our interactions with police and what they may do at the time of arrest or custody. And what the Warren Court held in this 5-4 decision is that at the time of arrest or custody, any statements made by the defendant are inadmissible unless the defendant is notified that what they say may be used against them. And this is a core part of the Fifth Amendment guarantee of due process and the right against self-incrimination. So let's look at the Miranda warning. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you cannot afford an attorney, one will be provided for you. Do you understand the rights I've just read to you? With these rights in mind, do you wish to speak to me? The answer is no, always. All my criminal defense lawyer friends tell me the answer is always no. I think that's good advice. So, the question this raises then, in modern litigation, we have to then ask, when are you in custody? Because, at the time of arrest seems relatively easy, right, at times, or custody, you would think so. But it turns out it's not always so clear. And this leads to great dissension within the courts in terms of battles over the scope of custody. Because the broader the scope of custody, the less the state can use in terms of, getting confessions and the like from people. The narrower the scope of custody, the more you can get confessions or statements from people that you can use to convict them. So let's take a look at this case. This comes out of the Fifth Circuit. It's a great case to go read. It's a fun case because it's got a dissent. You can see the differing judicial opinions to this day in 2022 over Miranda and the Warren Court precedent in terms of how things should be playing out. And so this is United States versus Coulter, 41F 4th 451, and this comes out of the Fifth Circuit. And so here are the facts. You have a lone police officer who does a traffic stop on Mr. Coulter in the middle of the night. Now, he was given reason to suspect that Coulter, was doing something. And Coulter revealed that he had an aggravated robbery conviction, had a gun, and so the officer handcuffs him and asks him where the gun was. Coulter tells him, and then the lone police officer's partner arrives, and they find the .40 caliber pistol and some marijuana in his backpack in his car. Now, before Coulter divulged that information, no one had given him any Miranda warnings. And so, he had been, pulled over, obviously. He had been handcuffed, and the police officer asked him, you have a gun, where is it? And he told him. So, he gets a lawyer now at last, and the lawyer says, look, this is a violation of Miranda. You have to suppress the statements, and you have to suppress the evidence, which means you got to dismiss the indictment. This goes to the Fifth Circuit, and in a split decision, here's what the majority of the Fifth Circuit panel held. We hold that a reasonable person in Coulter's position would not have thought that he was in custody for Miranda purposes. Moreover, the officer questioned Coulter in an environment that was not tantamount to a station house interrogation as contemplated by Miranda. All of Coulter's unwarned statements are therefore admissible. Now, the dissent said, whoa, hold on. You handcuff someone, you know, on the side of the road, you're a police officer, he's in handcuffs, feels a lot like you're arrested or in custody. And so the dissent says, and here's a quote from the dissent, the restrictions placed on Coulter during a traffic stop were of the degree associated with a formal arrest. In other words, come on, right? That's what the dissent is saying. When Coulter offered to walk away from his van before Officer Nino de Guzman searched it, Officer Guzman told him to turn around, face a squad car. He told Coulter that he had to back up around the corner. He also warned Coulter, don't run away or pull away, because if he did, I'll tase you. And so the dissent says that is obviously functionally an arrest or a formal, you know, placement in custody. And so everything should have been suppressed and the evidence should have been deemed inadmissible and the indictment should have been kicked out. But the dissent was the dissent. And so Coulter found himself not the beneficiary of what he probably thought was a pretty good Miranda type case. And so this is a great case to look at and go read, because it does show the lingering judicial battles that exist over Miranda and the lingering sort of comfort that many jurists have with the scope of Miranda in terms of the burden it's put on the state and the consequences of it. Let's take a look then at a more recent case from the U.S. Supreme Court moving along here, and this is the case of Vega versus Tico, 142 Supreme Court 2095, and this is a 2022 U.S. Supreme Court case. And we start asking the question of whether Miranda is starting to be narrowed, and is there something coming perhaps on the horizon with our ever-changing Supreme Court in the last few years, where we may see Miranda be further narrowed, constricted, killed even conceivably, right? I mean, who knows? But we have to ask a question because we saw the Fifth Circuit and the battle that's going on in the circuit courts, and now we have another Supreme Court case that was dealing with Miranda in a context. And so this case involved a situation where an officer questions Mr. Tico about his alleged sexual assault of a patient. He wasn't Mirandized. Tico then gives a written statement apologizing for inappropriately touching the patient's genitals. Boom. Tico then gets prosecuted for unlawful sexual penetration. And his written statements admitted against him at trial. The jury returned a verdict, though, of not guilty. So Tico's unhappy, though. Even though he got a not guilty verdict, which was sort of a great win for him, obviously, he sued in civil court under 42 U.S.C. 1983, the civil provisions for suing for violations of constitutional law against state officers acting under color of state law. And he said, I want damages because you violated my constitutional rights. You didn't Mirandize me. You used an un-Mirandized statement against me in a criminal proceeding, and that was unlawful, and that violated the Fifth Amendment. And so I want to now sue you for civil damages for the officer who went out and did this to me. The officer should have Mirandized me, in other words, and you chose not to Mirandize me, and now I get to sue you as an officer for violating my constitutional rights. This goes up to the U.S. Supreme Court, and in a 6-3 decision, they said, nope, Mr. Tico loses, Deputy Vega wins. And what the Supreme Court held 6-3 is that a 1983 claim can be based or must be based on the deprivation of rights secured by laws. But what it held is that Miranda's rules don't really constitute federal law in the way that Section 1983 is talking about it. And so they can't be a basis for a 1983 damages claim, because what they really are these judicial creations. They're judicial prophylactic rules is sort of the incanted phraseology of it, which is different to a law that 1983 required. And what the court then talked about here is that, in terms of then analyzing this question, it said that any benefit of allowing suits would never be justified by the systemic costs imposed on the system and against other officers of allowing these types of suits to go forward. It would just sort of open the floodgates to litigation in civil courts, and we're not going to allow that. The best that we'll allow is that people can get a criminal exclusionary order, and that's the only remedy you get for a Miranda violation. Now, footnote, remember, and this is what the dissent said, a criminal exclusionary order may or may not work. What happens if the trial court denies it, you get convicted, you go to jail, you spend 3 years in jail, and then the Court of Appeals says, yeah, that violated Miranda, and they let you out. You've now spent 3 years in jail. What about getting some, financial compensation for that in 1983? But it was the 3 in dissent who said that. The 6 in the majority said, nope, you don't get anything. So This is a narrowing of Miranda in some significant sense, really. It was a massive case that went up. And so who knows what it portends for the future? Stay tuned. Now let's move to our just compensation for property seizure module. And this, of course, is what's known as eminent domain. And the language is, nor shall private property be taken for public use without just compensation. Right. Let's take a look at the basic ground rules. And these are the ground rules that come from the U.S. Supreme Court on eminent domain. And this is distilled from several cases. You can see several of them here that I've quoted. And what I really did was distill out the major rules for you so that you could become the curious lawyer expert on eminent domain. And so here are the rules. The sovereign cannot generally take the property of person A for the sole purpose of transferring it to another private person B, even if A is paid just compensation. And so the point here is that there's no such thing as pure private takings. I mean, the government cannot simply be involved in taking my house and giving it to you, even if they compensate me, even if they give me great compensation, supermarket compensation. Can't be done because there's absolutely no pure private takings. The next fundamental principle here is that you may take from one private party and give to another private party if the future use by the public is the purpose of the taking. So in other words, if the taking is being done and a transfer is going between private to private, but it's for public use down the road, then it's okay. And so the most basic example that the Supreme Court regularly talks about and all the courts talk about are sort of the historical ones of condemnation of land for a railroad with common carrier duties. And that's just your standard example. It's private land, it's going to a railroad, a private entity, but it's in order to create this public use in terms of a railroad that's a common carrier for the public. And so the Supreme Court then has long rejected any literal requirement that condemned property be put into use for the general public. And that's a critical pole star. And instead what it's done is it's adopted a test around there being some sort of public purpose for the taking. It doesn't have to be a complete public, 100% general public grant. Instead, it's a public purpose that's around the taking. This, of course, as you can imagine, is far more malleable. And so we're going to look here at a few quick cases to understand these basic ground rules. And then we're going to look at a couple very, very modern cases to understand the massive tension that's in the Supreme Court over the scope of the state's eminent domain power. So we're going to go in order. We're going to go from 1906 to 1954 to 1984. We're going to it's an odyssey through the 20th century. Let's start in 1906. And this is the case of Highland Boy Gold Mining Company. Strictly versus Highland Boy Company, 200 U.S. 527, page 531. And here the Supreme Court affirmed the eminent domain taking in a case where it upheld a mining company's use of an aerial bucket line, the sort of equivalent right to a railroad. It was doing this sort of aerial bucket line for a mining company. And it needed this in order to transport iron ore over property it did not own. And so that taking to allow it to transport iron ore over someone else's property was affirmed as being within the public purpose concept like railroads and common carriers, because even though it was given to a private company, this is to ultimately get public goods like iron ore that are public purpose type uses for the public, and so that was an affirmed takings. We then go to the mid-20th century, 1954, and the Supreme Court affirmed a redevelopment plan targeting a blighted area of Washington, D.C. And what happened is in D.C., the findings that were made by the local government were that most of the housing of the area's 5,000 inhabitants in this particular neighborhood area were beyond repair. And so a plan was formed where the entire area would be condemned, and then part of it would be utilized for the construction of streets and schools and other public facilities. So you'd have some public stuff going on in this new kind of neighborhood, so to speak, that was created. But the remainder of the land would be leased or sold to private parties so that they could then go redevelop it, including requirements for the construction of low-cost housing to help people. And that plan, over the objections of the private landowners who said, I don't want my land taken so it can be given to another private company who's just going to create housing, like I want to keep my house. Well, too bad, the Supreme Court said, because that was a public purpose for the taking. And that's the Berman versus Parker case, 348 U.S. 26. Now we go to the late 20th century, 1980s, and this is a case coming out of Hawaii where there was a state Hawaii statute that authorized fee title in land to be taken from lessors and transferred to lessees where they were being paid compensation. But this fee title that was being transferred to new lessees, to the lessees from the lessors, was being done in order to reduce the concentration of land ownership, in order to sort of, more equitably distribute land, right? That was held by the U.S. Supreme Court to be a legitimate public purpose taking also. Now let's take then a look at a 2005 case which has sparked some controversy, and this is Kelo versus City of New London, 545 U.S. 469 in 2005. And so here are the basic facts. It's kind of like the mid-20th century case we just looked at in terms of a city dealing with urban blight and redevelopment. And so what you had is the City of New London in the year 2000 approved a development plan. And this is in Connecticut, and the case went up to the Supreme Court of Connecticut, and what the Supreme Court of Connecticut said was that this underlying city plan was to create 1,000 jobs, to increase tax and other revenues, and to revitalize an economically distressed city, including the downtown and waterfront areas that were distressed economically. And so under the plan, property was to be bought, and eminent domain would be used to acquire the remainder of the property from unwilling owners, people unwilling to sell, who'd be then given just compensation. All of this would be done so that you could take this kind of perceived economically distressed area in urban blight and kind of make it nice, new, and shiny and create jobs and all the like, right? And so the issue then that went up to the U.S. Supreme Court was, does this more generalized economic development idea, does that satisfy the public use requirement of the takings clause? In other words, can cities just simply say in the name of economic development, just to make something look nicer and better and create some jobs, that we can actually, flex our eminent domain power? And in a very close decision, it was 5-4 split decision, the Supreme Court said, yes, it can. Now remember, this was a 5-4 decision allowing this kind of economic development to satisfy the public use requirement, but this was the 5-4 decision in 2005. And of course, in 2023, we have a radically different Supreme Court, a majorly different Supreme Court, radically little r, of course, but it's a very, very different makeup to our Supreme Court makeup in 2005. So this is why the case has continued to spark some controversy, because it was very close even at the time. And so here's what the majority said at the time. It is not for the courts to oversee the choice of the boundary line, nor to sit in review on the size of a particular project area. Once the question of the public purpose has been decided, the amount and character of land to be taken for the project and the need for a particular tract to complete the integrated plan rests in the discretion of the legislative branch. So it was very, very deferential. Moving forward, let's take a look at a 2021 case that almost went to the U.S. Supreme Court, Etchainer versus City of Chicago. And cert was denied, but you had a dissent from denial of cert by Thomas and Gorsuch, and Justice Kavanaugh also voted to grant. So 3 of our current makeup were distressed, and this was a square challenge to Keto. And basically, this is another situation coming out of Chicago on a somewhat similar fact pattern to the Keto case we just looked at. And here you had Etchainer owned a tract of land in Chicago's River West neighborhood. 2 blocks south, there was a factory and a chocolate company, and the company basically wanted Etchainer's land to create a buffer with nearby residential areas. So it offered to purchase the property. He declined. Eminent domain then followed on the basis that if he didn't give up his property, this whole area was likely to become blighted. And the eminent domain then was affirmed. And so this is an example of sort of this idea of, wow, we are now allowing eminent domain on potential blight and potential future harms. And so the Kelo case was front and center, but under Kelo, this was sort of within the realm of what was a legitimate use of local eminent domain power. But you did get this very, very strong dissent from 2, with Kavanaugh agreeing that this case should go up, arguing fundamentally that Kelo was wrong. I mean, the square argument was that Kelo was wrong, eminent domain power to cure suspected future harms is just not an appropriate way the government should operate within the Fifth Amendment. So stay tuned, because this area is going to get some more cases from the Supreme Court in the coming years. And I would suspect, given the current court makeup, we will see perhaps some retreat on the scope of Kelo in terms of the breadth of when urban blight can be sort of a goal to allow taking. Let's move now to our due process module on a fair trial, where one cannot be deprived of life, liberty, or property without due process of law. And this has a procedural and substantive due process concept, as you know. And the procedural idea is that procedural due process really focuses on a fair trial or a fair state proceeding that where you have notice, an opportunity to be heard, the ability to gather witnesses, the right to put on a case to be heard, right? It's the procedural accoutrements to a process that, if they exist, they guarantee then that the adversarial or the administrative process has worked fairly, and that is the nature of due process. Broadening out from procedural is the idea of substantive due process. It started in the early 20th century. And it's evolved as a means of using the due process clause to protect substantively against state action certain substantive rights. And those are rights that the Supreme Court and other courts have deemed fundamental or implicit in the concept of ordered liberty. And thus, they protect a range of behavior beyond just how trials or proceedings unfold, but your rights, your sort of substantive rights vis-a-vis the state, which means the state can impinge or infringe upon them. And protection of those rights in the name of due process is substantive due process. A quick practice pointer for those of you who are advocates, whether you're in the courts or just arguing to cities and agencies, and I teach this to my law students. I teach at UC Irvine School of Law always in my clinic, and that is, whenever we're framing arguments, frame them as much as possible in procedural irregularities if you can, rather than making general fairness arguments. And that's because when you're arguing for substantive general fairness, you're always arguing to a narrower pool of jurists, I believe, than when you're arguing for procedural propriety and procedural regularity. Procedural fairness is something that can animate jurists from all political spectrums, whereas substantive fairness or substantive outcomes will sort of be on one end of the spectrum or the other, depending upon what you're arguing for often. So that's a good little practice pointer and as a side here in our Curious Lawyer program. Let's take a look at a couple cases, though. And here's a procedural due process case. This comes out of the Ninth Circuit. It's Padilla-Augustin, 21 F. 3rd 970, and this is the Ninth Circuit in 1996. And it's an immigration case where basically someone loses in their immigration asylum trial. They're ordered deported. They file an appeal on a notice of appeal form. The form says, state the basis for your appeal. And he specified the reasons for his appeal, and it told him, fill out more sheets if you need it. So in any event, he files his notice of appeal, puts down his explanation for why he thinks he should win on appeal. His appeal then goes up to the Board of Immigration Appeals, which is the agency appellate within what was then the INS, and they just summarily dismissed it. This thing goes up to the Ninth Circuit, and the Ninth Circuit then held as a matter of procedural due process that the form itself wasn't fair. The form and the regulations gave the idea that you could, within like 1.5 inches or 1.75 inches, you could explain the basis for your appeal, and that would be enough, and you would think that you would have an appeal heard. And it's a game of gotcha in essence when your appeal then goes up and they say, oh, you didn't give me enough information, so I'm just going to summarily dismiss the appeal without kind of even adjudicating it on the merits because you didn't give enough clarity and you were only given 1.75 inches of space to even give the clarity. And so this was, and the Ninth Circuit then held with a panel of conservative and liberal jurists, which goes to my advocacy point I made to you, that this violated the procedural due process rights of the immigrant, the alien. It just was an example of procedural due process where a fair process and hearing couldn't occur because of the nature of how the form was working and what was being allowed to happen. And it appealed to all jurists, right? So now let's broaden, and we'll just take another Ninth Circuit example on a very controversial issue. And I picked this one because it's also 1996. 2 1996 Ninth Circuit cases, one procedural, one substantive due process. Let's take a look at substantive due process. And this was the compassion in dying case. It's the famous right to die case that you all may remember that was percolating in many federal appellate courts in the 1990s, and eventually goes to the Supreme Court, as we'll see. And so we see the battle between the Ninth Circuit and SCOTUS on this substantive right. And so what the Ninth Circuit held in this en banc decision is that the liberty guaranteed by the due process clause is broad, and it's not, a very, very specific pinprick things here and there, such as freedom of speech and religion or the right to bear arms. Instead, the due process clause protected substantively a freedom from substantial arbitrary impositions of the government and for the right to reasonable and sensitive judgments being issued that certain interests get particular scrutiny before the state can abridge them. And so what the court held, as you see here in our bolded language, is that in these right-to-die cases, this is sort of euthanasia in essence, where states were precluding doctors from allowing terminally ill people, allowing the doctors to help terminally ill people engage in physician-assisted suicide. The Ninth Circuit held in this en banc decision written by Judge Reinhardt at the time, we hold that a liberty interest exists in the choice of how and when one dies, and that the provision of the Washington statute banning assisting suicide then violates the due process clause. And so this is an example of substantive due process being the choice of how and when you die is a fundamental right implicit in the concept of ordered liberty that we have, which means the state can't interfere. Now, this case provoked a dissent. Here's the Ninth Circuit dissent. And the reason I gave you this dissent is this dissent was written by Judge Fernandez of the Ninth Circuit in 1996 saying no substantive due process right. And the reason I picked it is because the Padilla-Augustin case you just looked at in the Ninth Circuit was also written by Judge Fernandez, who found a procedural due process violation. So you see here how this jurist was on either side. And also Judge Reinhardt was in both cases, and he, in the procedural due process, found a violation, and in substantive due process was the one who wrote the en banc opinion here. But here you have Judge Fernandez saying, in my view, no one has even a non-fundamental constitutional right to become what our legal ancestors pithily denominated as a fellow de se. And so he said no such right. In any event, this case and a Second Circuit case like it on substantive due process went up to SCOTUS, and in Vacco versus Quillen 1997, SCOTUS said 9-0. No such substantive due process right. This is very, very difficult stuff. It's complicated stuff. It's troubling stuff, but it's stuff that's within the power of state legislatures to allow or disallow, and we're not going to allow the Constitution as interpreted by judges and justices to intervene. And so it was a 9-0 shutdown on substantive due process. And so you see there the limits of due process coming out of the Fifth and, of course, the 14th Amendment in terms of how courts will look at it. But it's a fantastic use of those dual cases because you see jurists being able to find procedural violations but not substantive ones. All right, the final little point we'll make here as we wrap up is, has this been incorporated and has the Fifth Amendment been incorporated and applied to the states through the incorporation doctrine? And under the incorporation doctrine, as you've seen in our other Curious Lawyer programs, we try to figure out whether the 14th Amendment enactment has made all of the Bill of Rights provisions applicable to states. And here, when it comes to the Fifth Amendment, everything has been incorporated through the 14th Amendment and made applicable to the states, except for the grand jury requirement. Now, that said, most states have created grand jury rights by their own positive state law, so it's in effect a moot point. But nonetheless, all of the Fifth Amendment has been incorporated by doctrine and made applicable to the states. That brings us then to our conclusions on our 5 pillars to the Fifth Amendment. You have a right to grand jury for felony indictments, and there are limits about the First Amendment that allow grand jurors to then later discuss what happened. We learned about the prohibition on double jeopardy. There's no Ashley Judge free pass on murder. We learned about the right against forced self-incrimination. Miranda's still strong, but it is being battered. So here, stay tuned. I think we're going to start seeing more and more changes on the horizon in the coming years. And so you as a curious lawyer, you may want to watch our Fifth Amendment program in a few years, and there may well be radical new changes to it. That is certainly true, too, on the final point about seized private property. What's a public use? Stay tuned there. I think we'll be seeing changes given whether that Kelo case is right or wrong. And, of course, we saw the fascinating final module we looked at with respect to the guarantee of fair trials to criminal defendants and the nature of substantive versus procedural due process. Thank you very much for watching. I hope you enjoy our Curious Lawyer Bill of Rights programs. We have all of them there for you. Please learn about all 10 amendments and our other range of Curious Lawyer programs. And if ever you have questions, as always, please reach out. Thank you very much.